One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
Innovation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
And welcome to the show. Today, our topic is how to remedy violations of the due on sale clause. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the channel, make sure to like us, and you can follow us, and you can find us at the following places: Facebook, X, and YouTube. At each of those places, we are at the handle at InRem Podcast. That's at InRem Podcast. Also, whether it be Spotify or Apple Podcasts or any other podcast platform, you can download an audio version of the podcast. Make sure to go there, do that. Helps us out a ton. We appreciate it a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today, as you may expect, is another Corporate Transparency Act update. And this, I think, will be my final one for at least 4 years. So that's awesome. So the update that I provided last time was that the Treasury Department, or FinCEN, and the Department of Justice appealed the last case that was remaining with an injunction in place, and they appealed it and asked the district court, as well as part of the appeal, to set aside the injunction in light of the United States Supreme Court decision in the Top Cop case. And the judge then granted that request for relief, set aside the injunction, and then FinCEN set a date of March 21, 2025 for everyone to file their beneficial ownership reporting information, or for all entities to file their beneficial ownership interest information. And so it was like, oh, okay. And that was my last update last week, was, hey, you're going to have to comply by March 21. Unfortunately, we thought things would go different. Well, then last week, the Treasury Department came out and said, well, hold on. We're not going to enforce it if you don't file by March 21. In fact, we're going to rewrite the rules before March 21. And as a result, we're going to extend the date. And so even if you don't file by March 21, there's no enforcement. So it's like, okay, well, there's some relief, and we'll find out what those final rules were. Well, then on Sunday, March 2nd, 2025, the Treasury Department released a statement or an announcement regarding the enforcement of the Corporate Transparency Act. I love the fact that this came out on a Sunday. Like, they're working on Sundays now. Imagine that. The government is actually working on Sundays and issuing press releases on Sundays. And so I just want to read this to you because it just sums it up. It's going to basically be my last Corporate Transparency Act announcement. So the press release says, the Treasury Department announces suspension of enforcement of Corporate Transparency Act against U.S. citizens and domestic reporting companies. And then the press release actually states, the Treasury Department is announcing today, a Sunday, that with respect to the Corporate Transparency Act, not only will it not enforce any penalties or fines associated with the beneficial ownership information reporting rule under the existing regulatory deadlines, but it will further not enforce any penalties or fines against U.S. citizens or domestic reporting companies or their beneficial owners after the forthcoming rule changes take effect either. The Treasury Department will further be issuing a proposed rulemaking that will narrow the scope of the rule to foreign reporting companies only. Treasury takes this step in the interest of supporting hardworking American taxpayers and small businesses and ensuring that the rule is appropriately tailored to advance the public interest. This is a victory for common sense, said U.S. Secretary of Treasury Scott Bessent. Today's action is a part of President Trump's bold agenda to unleash American prosperity by reining in burdensome regulations, in particular for small businesses that are the backbone of the American economy. So what does this exactly mean? It means that for at least the next 4 years, there will be no beneficial ownership interest reporting under the Corporate Transparency Act if you are a domestic LLC or a U.S. citizen. You do not have to report this information. And why do I say for the next 4 years? That's because the Corporate Transparency Act, while passed by Congress and is a law that's enforceable, the act gave to FinCEN, a federal agency, the ability to write the rules. And so when the rules came out and deadlines came out that you had to file this stuff by, for any entity that was formed before January 1, 2024, and then you had to file it before the end of 2024. And what you had to file, you had to submit your driver's license and your address and provide all this detailed information regarding the owners of the business. All of that was actually created by rule. That was not part of the Corporate Transparency Act. The Corporate Transparency Act just said, hey, the federal government can request this information, or FinCEN can request this information as the authority, but they decide what is requested. They decide who submits. So, what LLCs have to report. So they're the ones, FinCEN is the ones that said, oh, well, if you gross over 5 million or you're a publicly traded entity, oh no, you don't have to report. We just want the small businesses to report, right? We just want to put it on the backs of the small businesses and give them extra paperwork and expense, and that was FinCEN. That was the prior administration that did that, right? Well, the new administration, which will be in place for 4 years, said, no, we're not going to do that. We're going to rewrite the rules, and it's only foreign companies. We're not going to make U.S. citizens, small businesses, have this extra paperwork and expense to operate. We're just not going to do it. And so for the next 4 years, we know that that's what's going to happen. This could change though, right? If next presidential election, it shifts and you have a more regulatory prone party get into office, they are probably going to do what the last administration did and have these, egregious onerous requirements on small businesses. And so, who knows what the next 4 years will bring, but right now we know that there is no reporting requirements here for the next 4 years. And I also think, and we've had shows on this, there's this real estate reporting rule that goes into effect December 1, which was also a FinCEN rule, which requires title companies, attorneys, anyone assisting with the transfer of property, residential property, from into an LLC where the LLC is not obtaining any type of federally insured loan for the purchase. So a hard money loan, cash, etc. Even some transfers for estate planning. You're going to have to report all the same information to the federal government, to FinCEN, and that comes into effect December 31 or December 1 of 2025. I'm guessing that's going to go away before it ever comes into effect, but I guess that's going to be a fight for another day. But as for now, it's a victory for small businesses, and for at least the next 4 years, there's no reporting requirements for U.S. citizens and domestic entities under the Corporate Transparency Act.
All right. Thank you, Sean. Thus ends the roller coaster ride of the Corporate Transparency Act, at least for the short and medium term. With that, a couple of reminders, or a reminder for you in this episode. If you have questions relating to our topic today, I want to make sure that you post those in the comment from whatever platform that you're watching. We're monitoring the comments and we'll address any questions that you have in the final 15 minutes of the show. So post them there while you're thinking about it before you forget about it. With that, we're going to go ahead and jump into our topic today. Today, our topic is remedying, fixing, in other words, violations of the due on sale clause. What is the due on sale clause? Well, we're going to talk about all that, and we're going to talk about how to remedy violations of that. With us to discuss that is our friend Alan Ceshker. Alan, thanks so much for being with us.
You bet, you bet. I appreciate y'all letting me be on.
Yeah, no, we're happy to have you, and always enjoy when you're on with us. Now, for those who have watched us for a while, know Alan and have watched him a variety of times on our show and may be familiar with him. But for those who haven't, you're an attorney in Texas. Why don't you tell our listeners about yourself, how you got into doing what you're doing, and a little bit more about your law firm?
Good deal, good deal. Yeah, so we're in Texas, a law office, but a law office focusing on real estate transactions. We're what's called a fee office, a title office owned by an attorney. And so the law office helps with all the creative, complex stuff that goes on out there, and like we're talking about today. And then the title office closes just everything from the normal stuff to the wild, wacky, creative stuff. And then we do try to educate quite a bit. We have an event the second Tuesday of each month. We have Rap University, and on April 12th, we're doing Rap University 2.0 because it's been about, I think, 5 years since we started Rap University, and there's been some changes like the due on sale clause that we're going to talk about today. And then we got some exciting stuff coming down the line. Like I did with mortgage wraps, I'm going to take everything that we know from just simple wholesale stuff to novations, et cetera, and create what I'm calling Ultra, the ultimate law, title, and real estate advising. So keep an eye out on that. But yeah, we're a law office, but really just a glorified title office that can do more.
Yeah, good stuff. Now, if you're watching and listening to Alan talk about Rap University, I want to note that just next to my forehead there is a barcode. Scan that. That'll take you right to Rap University. We'll have that up for just a minute or so. But go ahead and scan it, and it'll take you right there. Now, if I'm new to creative finance, new to learning raps, maybe I've heard about them. Is this a good place for somebody that's new to the industry and just learning about what these transaction documents look like in the process?
Yeah, it is. The Rap University is a 4-hour course. We have 1-hour courses, and that's usually not for beginners necessarily. But the Rap University starts from square zero and then takes us all the way up to managing these things post close, fixing problems, and things of that nature. All
right, good stuff. So if you're interested in learning all about the Rap process, now as I recall, Sean, you've even been to Rap University before, right?
Yeah, it was awesome.
All
right. I went from Phoenix to Dallas. I flew there just to attend Rap University, and it was worth every penny. So definitely, if you're wanting to learn more to develop, this subject to Rap transaction and learn it, you definitely should go and learn from the best.
All right, good stuff. Scan that barcode and go to Rap University. With that, we're going to get into our topic today. And one of the things I'll bet you would learn in Rap University is a little bit about the due on sale clause, probably. It is part and parcel to an issue that you might face if you're an investor in the space of creative finance, but you don't have to be. If you are somebody who's involved with any sort of real estate loan, whether you know it or not, you've probably been involved with or signed contracts, I should say, that have this thing called the due on sale clause. If you've listened to our show a number of times, you've heard us talk about it. Maybe you've wondered, what is it? Why is this thing? Why is this thing they're always talking about? What does it do? What are its effects? We're going to get into all that. So why don't we kind of start at the bottom, Alan, and break this down for everybody as we work into more details. Let's just start simply, though. What is the due on sale clause?
Yeah, so due on sale clause, first off, it's not in the promissory note. It is in the deed of trust, and it's in 99.9 deeds of trust for residential mortgages. And I break it down to simply it's the right of the lender to call the note entirely due if you sell their collateral. And what's important there is it sounds like an absolute deal killer, but as we'll dig in today, we'll find out that it's not necessarily as prevalent and dangerous, but it is something that has to be dealt with. So the lender can say, all right, you owe $400,000 on this mortgage. We saw you sold our property, our collateral, excuse me. So now you owe $400,000 immediately. So it sounds dangerous.
Is this something that you would see in every single loan? I mean, I kind of think maybe you just answered that when you talked about the fact that collateral has to be kind of part of it. Kind of explain why it might not be a part of some and why lenders care about it being a part in others.
So we've closed a mortgage wrap, and so we had the due on sale notices and things of that nature embedded in there. And the seller came and said, "No, there's no due on sale clause on this thing." And I said, that can't be true. And so went through it and found out that there wasn't. And then on commercial transactions, there may or may not be a due on sale clause. However, on the commercial side, all we do is ask the commercial lender, "Hey, can we sell this via a wrap?" And they come in, analyze, and take a look at it, and 9 times out of 10, they're agreeing to that. So it really resides over in the residential arena in just about every mortgage that's in place.
Now, let's talk though that, because you already mentioned one transaction where the due on sale clause wasn't there. I mean, it's not a legal requirement to have a due on sale clause in your loan documents. And so if you're an investor buying on a wrap, you probably don't want the wrap documents between you and the seller to have due on sale in it, right? Because you may want to do a disposition on the back end.
Yeah, absolutely. So our mortgage wrap loan documents come in several different forms, and investor buying will have a deed of trust that does not have the due on sale clause. It's a nicety that the mortgage companies threw in there a long time ago. And then there were some statutes that came and say they exempted some transactions from a lender being able to call it due. That's the Garn-St. Germain Act, as y'all know. But on the acquisition side, there's no due on sale clause for our investors. On the sale side, there is, unless they tell us differently.
Mm-hmm. Right.
So is the due on sale clause a standard clause that has standard phrasing? In other words, it's going to look the same in every single mortgage document that I find, or is it unique to every different type of lender that might use it?
It's normalized either, on the government side, FHA, they have their clause, and I think the big banks have something that's just a little bit different, but ultimately says the exact same thing. We can call this thing due if you sell our collateral.
Yeah, and I know what's interesting is in studying the Fannie Mae Freddie Mac due on sale clause, which I think is the broadest out there, or that I've seen. It's interesting that it's not just a sale of the property. It could be entering into an option to purchase the property, or an escrow instructions that's going to result in the subsequent sale of the property. I mean, they even have language to that effect, which is really broad because in theory, if you enter into a purchase contract, you deliver, that's basically escrow instructions to sell the property. And that should trigger or could trigger the due on sale clause.
That, and also they usually have a time period for renting. You can rent it for less than 3 years, but after that, you're triggering that due on sale clause. And I guess we should come back and say it is a permissive right of the lender, as opposed to a failure of payment. That's a default by definition. It's not a default when you sell that property. It's just a permissive right of the lender. And people like to draw that distinction. I kind of don't care as much, but it does need to be pointed out.
So why do lenders even care? What is the purpose of the due on sale clause? Why do they even put it in there to begin with?
I don't know. And so when we were passing mortgage wrap legislation in Texas a few years back, had the luxury of being able to ask the big bank lobbyist, "Why do y'all care?" And he was up there arguing that it could hinder our ability to foreclose. And so I said, "How? You foreclose against a property, not a person. How is it going to hinder your ability to foreclose?" And then as I kept questioning him, the commissioner said, "Stand down, Mr. Ceshker, because that's not the forum for adversarial back and forth." And so, and then I asked an attorney. We had a due on sale issue blow up, and a little bit different. The borrower was actively trying to get this thing to blow up, and so I took the opportunity to ask that attorney, "Why do you care?" And he said it's a violation of the deed of trust. I said, "Okay, yeah, but why does your lender care? Why does your client care that now there's two people that are required to pay this mortgage? Seems like it'd be a betterment. I want 2, 3, 4, 5 people to pay mine." And he never gave me an answer either. So, I'm getting old, but I hope there's an occasion where I can sit down with an attorney, maybe have a scotch or what have you, and get into a discussion about why do they care. And the reason I want to do that is I want to create what I'm going to call approved non-qualified assumptions eventually, where they say, "Okay, we'll waive our right to call this thing due. Just make sure your payments are being made." But haven't had the opportunity yet, and I've got no answer as to why the heck a Deutsche Bank over there with 1,000 mortgages tied up in some tranche would say, "We don't want this to occur," or a loan servicing company that gets paid per unit per month. Why do they want to blow up a mortgage just because of a due on sale clause? And I do not know.
Have you found that we don't know why they care, but apparently some of them do care? Have you figured out that or determined that there's certain lenders that care more than others?
Not lenders, but loan servicing companies. We've noticed. Well, strike that. On the big banks, loan servicing company, and so I don't know if I don't see any reason I can't name names. Home Loan Serve is the one that's out there actually looking, and they've told us they're looking, and that's been the uptick in due on sale issues over the past 12, 18 months has been mainly Home Loan Serve. But other banks that are watching a little bit more closely just because of their structure, credit unions, small town banks, and things like that. But I have found small town banks don't care either. They just may find it, and then we've spoken with them and said, "Hey, there's no problem with this. Let's continue forward," and they've agreed. But certainly haven't gotten to that level of conversation with the big banks.
Now, Alan, as we kind of established earlier, not every due on sale clause looks exactly the same at every bank. They might all have their different due on sale clause. The purpose of each one of those is to do the same and to protect the lender in the same way. But the devil is in the details, and oftentimes the details in the language on due on sale clause is just how broad that they are. How broad is the language? How expansive is it? And what kind of events does it kind of allow for to trigger the due on sale clause? And that can vary from lender to lender. So let's talk through a couple kind of transactions or things that are done that are common things that trigger the due on sale clause. Because oftentimes what I've found is folks trigger it by accident, doing things that they didn't even think about. Obviously, the most obvious is I sell my property to you and you pay me money for it, like in a normal deal, but we don't tell the bank. That triggers a due on sale clause, right? In every situation. But that's not the kind of thing that's typically happening that catch people by surprise. It's the little things that they're not thinking about. What examples do you have of kind of common scenarios where that clause can be triggered?
So a contract for deed is going to trigger that. I don't know if that has a 3-year time limit or not. I'd have to think about that, or maybe Sean, you got some info on that. A lease purchase option, rent to own, especially for longer than 3 years, and then just a straight lease for longer than 3 years are going to trigger that due on sale clause. Like I said, 99 times out of 100 in terms of the language that's in there, and that's the only ones I can think of.
Well, one that comes to mind that I see all the time, and maybe it's just because my practice area, I run into this, are folks that husband and wife who got a little bit of money in the bank decide to go get a rental property, and they go put it in husband and wife LLC, right? And they think, well, I got a mortgage on it and everything else, but I'm going to transfer it to the LLC because I want that to be kind of the property manager, or I want that to be the owner for leasing purposes. No big deal. Just transfer it over. did I just violate the due on sale clause? But yeah, I think in most situations they probably did, and I have to warn people about that. That's a common one I see. That's just a random event that nobody's really even thinking about.
Yeah, yeah. Transferring to LLC is extremely common. You know, folks will get a mortgage even on the investor side, and then move it over to an LLC after closing because lender doesn't want to lend to that LLC. And so, strictly speaking, it's a violation of the due on sale clause. I've never seen an issue, and I don't worry about it. I have to advise on it, obviously, as an attorney, but I don't worry about it. And the reason is, I know that we're going to be able to correct that due on sale issue by just deeding it right back over to the owners, to the borrowers on that. You run into an issue when you can't do that fix when the seller borrower is gone. But these folks who are just putting it into an entity for liability protection or what have you, we can cure that easily.
And to add to that point, not only is it easily cured, but the due on sale clause letters that I've had to deal with and worked with give three options, even though technically, like Andy said, they don't have to give the third option, which is the three options are pay the loan off, convey the property back to the borrower, which is the fix that you're talking about, or I've seen where it says, show to us that you are the 100% owner of the LLC. And if you can show that, then they don't care. So that's one where it falls within the clause, but they don't care. Mm-hmm. Although I did have one, and I think I've shared this before, but I had a client who their parent died, and it was held in the parent's trust. And then my client was the beneficiary, the wife was the beneficiary of her mom's trust. It moves down to her. She takes title. And then we go and move the property from the wife's name to the wife's trust with her and her husband on it. And so we put title into the name of the trust. And it was a small community bank. And they came out of the woodwork and they said, oh, you need to show us exactly what's going on with these trusts, because we don't think you were allowed to transfer, the properties this way. So I went back and said, okay, look, the borrower died. My client, the heir, had the right to inherit under Garn St. Germain, which we'll talk about in a minute, and keep the loan in place. And then she transfers it to her family trust, for which she's a beneficiary, which, I said, which I believe falls well within the spirit and purpose of Garn St. Germain and would be an exempt transfer. And they wrote back and said, no, the original borrower, it must be their trust and they must be the beneficiary of that trust. And so, no, that transfer wasn't appropriate. So you need to fix it. So, I mean, it was simple. We just moved the property back into the wife's name and then did a beneficiary deed naming the trust as the beneficiary, right? Pretty simple, and fixed it. But, to your point, why would the lender even care? But they did.
Yeah. And
so, I mean, that
one thing that's very important is, by state statutes and according to the promissory note and deed of trust, if you have a default in regard to payment or insurance isn't in place or some other type of default, then the bank, the lender is required to give you a 30-day notice before they can accelerate that note. And then if you don't fix in that 30 days, they can accelerate. It is important to note that the due on sale clause doesn't require that 30-day notice. And so especially a small bank that maybe they're required to get more funds in and they need to get rid of some loans, they could just call it due immediately and you don't get this little letter that says you have these options to fix. Now, I've never seen that, but it could happen.
Mm-hmm. Well, every due on sale clause that I've seen at least requires a 30-day notice of acceleration. So you, within that 30 days, so I will tell you the FHA and Fannie Mae and Freddie Mac loans all have a 30-day notice of intent to accelerate. That doesn't mean an option to cure. That just means, hey, we're going to call this loan due if you don't pay us off within the 30 days.
I don't think they have the 30-day notice of intent to accelerate. They only have the 30-day notice of acceleration. But we may have to review that offline. I don't know.
Yeah, maybe we're talking the same thing, but basically they can't start foreclosure proceedings for 30 days. They have to give the buyer or the borrower the right to pay it off within that 30-day period before they can start foreclosure. So I think we're talking the same thing, just using different language to describe it.
Yep, I agree.
So we've danced a little bit around this. We've made reference to statutes and even federal law, but let's jump into it here. Are there laws that outright prohibit a lender from invoking the due on sale clause in certain circumstances?
So the only one that I know of, certainly there's not one in Texas, but I don't know about other states, but the Garn St. Germain Act that we've been talking about lists, and Sean, you probably know it better than me. I'm familiar with the parts that affect me and my people, but it's, trustees, it's government, lenders taking property back, things of that nature. And then you get down to, I think, down the ninth one talks about utilizing a trust, like Sean was referencing, and that's the one that we piggyback on, and we can talk about it in depth. But there's usually not strict compliance with that. So when someone says, how can I avoid a due on sale clause issue? Is there a 100% way to avoid it? And the answer, at least from my opinion, is no. There's not. There's no federal or state statute that prevents lender from calling it due under the circumstances that we're seeing the transaction, an investor transaction.
Right. I think the most underutilized Garn St. Germain protection is the transfer to children. So I'll give you a scenario. I had a client call me, said, hey, I want to buy my parents' house. Can you put together the purchase contract and documents for that? And I said, okay, yeah, talk to me about what's going on with the structure. And they were going to go out and get a loan to basically pay off the existing 3% loan. They were going to get a 7% loan and pay off the existing 3% loan. And then they were going to give their parents some cash out of their pocket as, the down payment. Basically, they were going to have to put like 10% down. And I'm like, well, you have the cash, right? Yeah, I have the cash. Well, why are you going to go get another loan? Well, I thought we have to pay off this loan. I said, oh, no. Garn St. Germain says that a parent can transfer title to a child without paying off the loan. So you could just take over their loan. And that, it was like, what? It was like the greatest thing. Like I cut their interest rate in by more than half by that simple piece of advice. And so, when I think about it, I'm like, man, if your parents and you, and they can swing it financially and you can swing it financially, if they have a low interest rate loan, that golden ticket, man, you should never let them sell that property. Like you should buy it from them every day of the week because there's nothing the lender can do about it.
Yeah. And I think it helps people understand, and maybe you guys can go into really the purpose. I know the Garn St. Germain Act does a number of things, but with regard to the allowance of a transfer, like to children, like you said, or to a trust, there's a reason behind it, right? There's an estate planning reason. Why don't you break that down?
So with the way I think it occurred, I've never researched it. Sean, let me know if you have. But what I envisioned was lenders got smart, hired some lawyer, and they created the due on sale clause, and then that existed. And during normal estate planning efforts, creating trust and moving things over in trust, the folks were in technical non-compliance with the deed of trust. And so they said, hey, Mr. Legislature, we need to fix this. And they came along with the exceptions that now exist. And I think when they were doing that, they probably noticed, hey, turns out there's a bunch of other events that occur too. So you get this list of, I think it's 9 or 11 exemptions under that Garn St. Germain Act. Again, the one that we fall under is that trust. And technically, It says I can deed my property over to a trust, and I have to maintain beneficiary interest of the trust and reside in the property. So when we're duplicating that effort, we're not in strict compliance with it. However, we can go over some items. There's no way to tell we're not in technical and exact compliance with it, and that's what we're utilizing in the investor world.
Yeah. So I have researched the history of the Garden St. Germain. So you're tracking how it came about, but what's interesting is the reason why it was enacted was to preempt some what the banks considered rogue states that were not allowing lenders to enforce the due on sale clause as written, Arizona being one of them. So prior to the Garden St. Germain Act, we had a case, it was the Patton case with our our Arizona Supreme Court that basically came out and said, we think a due on sale clause is an unlawful restraint on alienation, and we will not enforce it as written. Instead, the lender must come in and prove that their security is being jeopardized by the transfer of the property. So they added the burden of proof. They shifted the burden of proof and added a requirement upon the lender, which is you have to prove your security's been jeopardized by this transfer, which of course they can't do, right? And so Arizona was one of about 10 states that this happened. And then there was some legislation that was being passed in other states. And so, of course, the bank lobby, credit unions, savings and loans at the time went to Congress and like, oh, you got to do something about this. Like, our loans aren't being enforced. And so the Fed said, oh, okay, we'll fix that. Any federally insured loan. So the Garden St. Germain only applies to federally insured loans. That's why those DSCR loans can prohibit like second position liens and things like that, which otherwise wouldn't be prohibited under, would be allowed under Garden St. Germain. But it applies to federally insured loans on residential property, and it expressly preempts any state law or state common law, case law that holds or requires that the due on sale clause be enforced in any other way than as written. So states have to enforce it based upon the language of the due on sale clause because of Garden St. Germain. But then, of course, it was like, well, yeah, but there has to be some exceptions here for estate planning, like you were saying, and other purposes. So actually what was interesting is, a lot of people are like, oh, it's due on sale, it's illegal, you can't do it because you're violating the loan documents. It's like, well, wait a minute. Before Garden St. Germain, we had Supreme Courts within states who were not enforcing the due on sale clause.
And of course, that makes a lot of sense, right? When you think about the fact that just a transfer a loan doesn't impair the lien, doesn't impair whatever position the lien is. The lender's really in the same position that they were with regard to that lien, So, and it was a market, or should be a market, that promotes the free alienation of your property, right? So makes a lot of sense. Alan, one of the things, or one of the main things that you do over at your law office is close transactions. So a lot of what we've been talking about up to this point in triggering the due on sale clause deals with, events that take place while you own your property that might result in, triggering the due on sale clause. But in your experience, as a closing attorney, what kind of events post closing do you see in your line of work that has the effect of triggering the due on sale clause?
So post closing, or I guess simultaneous, getting the insurance in place correctly is in my opinion the number one cause for a mortgage wrap to fail. And so utilizing an insurance agent that knows what the heck they're doing in regard to getting insurance in place for mortgage wraps is extremely important.
Now break that down just a little bit for us, because we haven't really been talking about creative finance or wrap so much in this episode, but explain just as easily as you can why that's the case and why that they should care about the insurance issue.
So once you get the insurance in place, that declaration page is going to be shipped over to the lender, and whoever gets that is going to start checking off boxes. All right, is lender in the mortgagee clause? And then they're going to be looking for their borrower to be on that insurance policy. And so if you don't own property, you can't insure it. So seller's insurance has to be canceled because they no longer own the property. If there was a claim, it'd be denied if they tried to file that claim under the seller's side of things. So buyer has to get insurance. Well, now buyer is listed as the insured on there. So there's two options. You can list the seller as an additional interest or additional insured. It's stronger if they're an additional insured. And so I say it's kind of an art in terms of how we're conveying that information over to the lender as opposed to science. I want an insurance agent that's going to be working on more than one level, meaning they send the deck page over there. If there's any questions, I want my insurance agent to get on the phone and start talking with the mortgage company and fixing this issue. And that's what we have now. When on sale,
Looks like we might have lost Alan. Can you hear us, Alan?
I saw I lost connection there. So I don't know.
You're back. Go ahead.
Yeah.
All right. Alan's frozen again. Maya, we'll see if we can get him to log back off and log back in. So we're talking about, I think we were in the middle of talking about the insurance issue and being a trigger of the due on sale clause. Sean, did you pick up where he left off?
Yeah. So my understanding, and I've went to Rapp University. We networked with Alan a lot and heard him speak on different occasions. And my understanding is, the insurance agent needs to be able to talk the right lingo with the lender and explain, look, the borrower's still on the insurance policy. They're here, they're listed, and talk to them about, why, that you have this additional insured there because they've,
Hey,
in any event,
I'm back.
they just have to be able to and point out, that the lender is still a mortgagee under the policy, et cetera. But I'll let Alan, since it looks like he's back up and running, talk more about the insurance.
Yeah, and I heard most of you. You're exactly correct. They need to know how to discuss the item, the lingo to use. And it's not, I get phone calls all the time from someone who says we're not using your preferred insurance guy, but we've got, Mitzi over here who we've been using forever. And we asked if she knows how to do this. She said yes. And then they call me and they say, hey, how do I do this? And I tell them, I said, I'm not going to advise you on that. It's too much liability for my side. And if someone calls me for an intellectual property case, I'm going to say no. And you should be saying no to insuring this property, because if you're not doing it day in, day out, you're going to mess it up. And then, people are going to start yelling at you and me. So it's knowing how to convey the information over to the mortgage company so that the person who gets that deck page can go check and then move on.
Mm-hmm. Beyond insurance, is there a particular way that at closing or post closing on a wrap you see getting the lenders all worked up and causing them to call the due on sale clause or trigger it?
Usually it's inappropriate contact with the lender, and we, a lot of times we'll have someone before closing, they'll send an email and say, hey, I called my lender and they said that I can't do this. And so we'll ask them, did anyone tell you not to call your lender? No, they didn't tell me that. And so a little bit of lack of education on the investor side. But we ran into a situation where in the normal course of a mortgage wrap transaction, we're going to ask for information from the lender. We need the payoff. We need the reinstatement if they're behind. We need a copy of the promissory note, and we need the current statement. We found that if the title office is asking for that in the normal course, we always ask for that in conventional transactions, but it could cause a problem. And so we've now taken the policy where we want the borrower to contact the bank before closing and ask for all this information. And that's just another way to prevent a possible problem prior to close. And then post-closing, we'll strike that. We also want all the contact information to be changed over to the investor. And we want that done before closing too, as opposed to utilizing an authorization. We'll get an authorization in place, but we'd prefer that to be all done before closing so that we don't have this possible inappropriate contact with the bank. So insurance and clumsy interaction with the bank is going to be the reason for 99.9% of the issues with a due on sale clause.
So I've heard, and maybe this is why you're having the borrower call, I've heard that there are some servicers who are now, like, one of the tip-offs is they receive a phone call from title requesting a payoff. They give the payoff, and then 60 days goes by or 90 days goes by, and they never get the money. That, they then think, oh, well, maybe something's going on. And they then pull that file and do the audit to figure out, has title been transferred? What exactly happened? Are you aware of that, being a situation?
Absolutely. We'll receive phone calls and they'll be asking for the status of transaction X, Y, or Z. And so my teams are taught, we don't answer that question and direct the phone call to me. And then I'll look at what's going on and provide an answer that causes them to bug out. But one, that the loan service that I mentioned, Home Loan Serve, they're actually looking at properties that were in foreclosure status that were reinstated. And they're looking to see if their borrower still has vested ownership of that. And if not, they're calling it due. And again, don't know why they're doing that. And so our solution on that is utilizing the trust vehicle, which we can talk about if y'all want to.
Well, why don't you break that down for us? What does that mean to utilize the trust vehicle to kind of assist with that?
So nothing illegal, but I would say it's leveraged tactical moves on our part. What we're trying to do is piggyback on the Garner-St. Germain Act exclusion, the trust. So I put my property into a trust. And if I remain as beneficiary and live in the house, then I'm in 100% compliance. But what we do is get the trust in place that causes the lender can't even check to see if there's compliance or not. So we're going to close the transaction. We're going to get all of our mortgage wrap loan documents in place, substantially similar. But when we deed this property, we're deeding the property from seller, the borrower, over to seller as trustee of the trust. So if the bank comes along and says, hey, what's going on with this? We need to know. I'll show them that deed and say, no, we're okay. Look, it was just a seller deeding their property to seller as trustee. And then post-closing, we're going to have a trustee change. If they want to dig further and say we want information in regard to the trust, we're not required to give beneficiary information. And so our certification of trust is going to, again, show that the seller deeded property over to seller as trustee of the trust. And if they ask who the beneficiary is, we're going to tell them to pound sand because they don't get that information. And think about it. If I have my underage children as beneficiaries of a trust, I don't want that information out there in the general public. So it's just not information we're required to give. So we have parent compliance with the Garner-St. Germain Act, and that's never been challenged. I'm waiting for that to be challenged because I'm going to enjoy it because the lender would literally have to file suit, send discovery, ask for the trust information, withstand a fight in regard to me providing that information, and then finally get that information. And then after we're 10, 12 months down the line, say, okay, we found out that this did violate the due on sale clause. Now we want to call it due.
So we've been, go ahead, Sean.
Yeah. And I think state law, at least in Arizona, on certificates of trust, basically, now, not all financial institutions accept this, but it says basically if you show up with a valid certificate of trust, which to your point does not have to name the beneficiaries. It just names the trustees. If you show up with a valid certificate of trust, that is supposed to be deemed sufficient for anyone dealing with the trust to rely upon.
Same Texas law.
Yeah.
Good. All right, guys, we do have a couple of questions. So with the time we have left, why don't we get to those while we're thinking about them? Mayu, if you would go ahead and post our first question. All right, it says from Tim, I'm buying from someone who bought the property subto and he is wrapping to me. Bank is lost payee seller and original borrowers are on it along with my name being the one insured. Do you recommend a servicing company? Question mark.
So it looks like you've got that all correct, but I call it a mortgagee clause, but lost payee is the same. Seller is also, since they're a lender in this transaction, they're in the same position as the bank, the mortgagee clause, lost payee. And then buyer has to be the named insured. That's correct. But we also want the seller as the named insured. And not all agencies will do that. We have three insurance agents that we referred to, and one recently said they could no longer put the trust as the insured, and we're having to move away from them, unfortunately. So we have to flex with what the insurance underwriters are allowing to be done. And then we do have a loan servicing company that we recommend. I don't know if they're just Texas based, but we recommend them because the owner is an investor closing mortgage wrap transactions and started a loan servicing company 4 or 5 years back. It's called Polaris. And so if y'all want the information for them, again, I don't know if they're outside Texas. I suspect they are. We can send that via whatever means we have.
All right, good stuff. Maya, did we have any other questions? All right. Can you use the trust vehicle in Texas? I know you can't do executory contracts.
So the answer is yes. And so I'm not a trust attorney. And when we started creating the trust vehicle that we use, I went and bought myself a real trust attorney. And we spent numerous weeks going back and forth. He's telling me about the tax implications and the liability implications. I'm telling him about what I need in terms of the mortgage wrap and compliance with Garn St. Germain. And so we went back and forth. And then during this process, I actually found out that we can utilize our trust vehicle all over the U.S. As long as the trustee is Texas based. And so we have done that on several occasions. I don't like it as much because it means that now I'm the trustee. My law office is a trustee, and there's not a bunch of liability on that, but we try to avoid all liability as lawyers. So it can be used outside of Texas also.
Mayu, did we have any other questions? Looks like that is those are our questions. Alan, so we've talked pretty significantly about the lender's rights in the event of triggering the due on sale clause. And we know from clause to clause, the amount of time or notice they might give, might be consistent, but whether you have an opportunity to cure can vary. What about on the buyer side? What kind of rights does the buyer have the property owner in this case, if the due on sale clause is triggered? Do they still have the normal rights to sell, refinance, do whatever they need to do once it's called?
Yeah. So the simple answer without doing these legal machinations and such is you pay off the mortgage, either pay it off via just straight, refinance it. We have had one situation where we had some complexities and couldn't cure. The only cure was to sell the property and pay that mortgage off. So that's the actual cure to a due on sale issue. These other items are the creative fix, and we normally we used to just utilize the deed flip flop, and so I'm talking about 3 occasions over the course of 15 years where we had a due on sale issue. It used to be a complete nullity. We would ignore it almost 100%. But with this uptick, and when I say uptick, I'm talking about maybe 10 out of numerous hundred transactions. So it's still a very, very small percentage, but if you look at it, it's a huge increase from 0.0000 something to 0.000 something. And so we don't necessarily do the deed flip-flop anymore. We will do the deed back to borrower and then utilize a trust structure to come back and protect it. Because again, the trust structure has never been penetrated, at least so far. And I've got a knock on my little table here. But we're ready to fight them when they're coming after us on the trust vehicle also.
So I know in Texas, you're a little bit limited on your remedies because Texas doesn't allow leases with options on residential property or contracts for deed or agreements for sale. So I'll just say outside of Texas, a go-to option, which brings you within the compliance of Garn St. Germain, in my opinion, is to do a 3-year lease with a purchase contract and an extended escrow period, which basically the purchase contract generally is going to be based upon the payoff of the existing loan and some amount potentially, depending on how it was structured. And then the lease payments just mirror what you were paying under the original transaction. And as long as you're not over that 3-year period, and then you do a separate purchase contract with a memorandum to purchase. I've never seen a lender call a loan due based upon somebody recording an affidavit or a memorandum of a contract. And that would be the only thing that gets recorded. So that would be outside of Texas, how, a transaction could be restructured. Obviously, tax wise, it may or may not be as good for the investor buyer, doing it that way, but nevertheless, it is a way to resolve it to your point, if you have a right to fix it.
And that's common. You'll see states that allow contract for deed, lease purchase options, Colorado, California, Florida, Arizona. And then you roll in there wanting to do a mortgage wrap transaction. Sometimes there's resistance to that. I like the mortgage wrap. It's, you get your homestead exemption, you're the owner, no more involvement from seller. It's a clean sale, clean cut. But you're 100% correct that a correction after a due on sale issue, or even a method to avoid the due on sale issue, is lease purchase option contract for deed.
All right, Alan, we have about a minute left here. With that time, what advice are you giving to wrap financing buyers on how best to avoid the lender calling the due on sale clause?
So the preventative measures are huge. Actually, even before that, educate yourself. There's got to be disclosures, got to be communication with the sellers, end buyers, and such. But the preventative measures are that get the contact information changed before closing. Get all the documents with the borrower asking for the documents as opposed to title, or you using an authorization. It's just not as safe. I'm not saying that on every transaction utilize a trust structure, but we're getting pretty close to that. If you have a seller that's going to be available for you, then you don't necessarily have to. If your seller is scurrying off, then go ahead and use the trust structure. And then get that insurance in place correctly. Utilize a proven insurance agent, and don't take chances on that. That's the reason they blow up. Not them coming and seeing the stuff, but being triggered by the insurance in place incorrectly. And then get yourself with an attorney that knows what the heck they're doing. This is not for the faint of heart. You don't go to ABC Title Company that's owned by corporate and hope that escrow officer knows what they're doing. You're using attorneys on this, attorney-owned title offices.
Yeah, here. Probably the most important thing Alan said. These are complex transactions. Whether you're experienced or new to this, you need an attorney in your state that knows exactly what they're doing. Alan, it's been awesome having you. Tell our listeners how they can find and connect with you.
So reach out to us, especially with that referral over to the loan servicing company. If you can spell my last name, Ceshker, that's the best way to get to us, Ceshker.com, Ceshker.com. and that has all of our contact information. We love helping folks both in Texas and outside of Texas. I'm a rap nerd, and so we don't mind the questions that we get. We've got a 15-page FAQ document that we can ship out, and anytime someone asks me a question that's not on that document, then it gets to be a little bit better document. So reach out if you need help.
All right. Alan Ceshker, thanks so much for being with us. Always enjoy it. Look forward to doing it again.
Thank y'all. Appreciate y'all.
All right. With that, everybody, that is our show. We will look forward to seeing you next week. Have a good one.
Have a good day, everyone.